Welcome everybody to the Spring 2020 Case Law Update. I'm John Nielsen. I am an Assistant Solicitor General in the AG's office, and with me is Lance Bastian from Utah County.
Hello.
So here we go. We'll start out this year with a quick retaliatory arrest claim. We talked about retaliatory prosecution claims last year. This one is somewhat related to that. Nieves v. Bartlett. Question in this case, does probable cause for arrest defeat a retaliatory arrest claim? The answer is yes, usually, or if you really dig into the opinion, almost always. So if anybody's looking for a good time in the era of social distancing and you want to get drunk, slap on some skis, and be pulled behind a snowmobile at 90 miles an hour, then just head on up to Alaska and attend Arctic Man. It's basically the Burning Man of Alaska. One writer described it as a, quote, week-long booze and fossil-fueled sled neck revival bookended around the world's craziest ski race, during which something like 10,000 partiers and their snow machines disgorge onto Camp Isabel's 300-acre pad to drink, grill, fight, and drink one last time before it all melts away. So clearly this is a recipe for peaceful interactions where nothing ever goes wrong, right? During that week, it actually becomes one of the largest cities in Alaska. And the event culminates in one of the toughest and most dangerous downhill ski races in the world, 5,800 feet high, then dropping to 1,700 feet in under 2 miles, where the skiers are then joined by their snowmobiling partner to speed to the finish line. So, like I say, recipe for peaceful interactions, right? Because it's in the middle of nowhere, Alaska, police are in short supply, so they bring in people from all over the state. They fly in officers from other localities, from state troopers, that sort of thing. But even during the busiest periods, there are not more than 6 to 8 officers on patrol for all of these hundreds or even thousands of people. So we come to Sergeant Luis Lou Nieves of the Alaska Highway Patrol. So Sergeant Nieves was on duty that last night of Arctic Man in 2014 when he had an encounter with Russell Bartlett that ended in Bartlett's arrest. And we actually have some video footage of that.
For 3 days, campers turned the Hoodoo Mountains into Alaska's 4th largest city.
It's Arctic Man. It's the Great Alaskan Springtime Passage.
They come from all over.
Lots of alcohol, definitely, firewood.
To see this. When the daytime races are over, the nighttime celebrations begin. Alaska State Trooper Sergeant Lou Nieves.
They gotta sit down.
Is in for a long night.
You gotta have a lot of patience for it. You're gonna contact some individual gears, right? No headlights.
Stops like this are pretty routine.
The fact that we have so many drones out here, I'm really worried that you're gonna get hit.
A motorbiker with no headlights is given a warning.
You stopped, you didn't run, you didn't polite.
A dangerous driver is told to slow down.
I know we're here to have fun and stuff, I know that.
And a snow machiner is pulled over, suspected of DUI.
It looks like these guys are good to go. Turns out that they're not like they're even got high five now.
As the night goes on, troopers turn their attention to the beer tent.
We're looking for the guy walking around, looking at the people.
They're also on alert for anyone underage. This 19-year-old's night ended here at the jail tent.
We can't drink up. There's no reason we can't drink up beer because I don't think so.
The party inside stayed peaceful, but outside.
Right there. Stop! 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 Who are you pointing at? He punched me. Who punched you? That guy.
The fight ends without any arrest. Later, more calls for underage drinking.
Shed a light on him. He ran from me. The costume. The boys didn't create safety. Hey guys. You got juveniles coming here and snatching your beer. So you don't keep the beer in here. Hey, back up. Back up. Back up. Back up. On the ground. 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 Now. On the ground. On the ground now. You're gonna get a taste. You're gonna get a taste. On the ground. Now you're going to jail. For what? Harassing my troops. I was not harassing. Yeah, you were. Walk away. Your commanding officer here now.
As the night comes to an end,
You're done. You're going to jail.
it's clear that Arctic Man 2014 was one weekend that won't be forgotten. Either by the folks out here, or the troopers working to protect them.
Let's try not to pick up any more cases. Yeah, and get the hell out of here.
John Payton, KTVA 11 News.
So it's like a small town Alaskan, I guess that's kind of repeating myself, episode of Cops, right? So just to fill in the rest of the story, we actually saw a little bit of what happened in this case. At about the 1:50 mark, we saw Nieves was talking to some partiers about moving their beer keg inside their RV because minors were making off with their alcohol. And Bartlett began yelling at the RV owners not to talk to police. So Nieves tried to talk Bartlett and talk to him, explain the situation, what was going on, but Bartlett was really drunk and he yelled at Nieves to leave. So Nieves left rather than escalate the situation, but several minutes later, Bartlett inserted himself in between another trooper and a minor suspected of drinking, so he was being a problem. And he was telling the trooper not to talk to the minor. The trooper then claimed that Bartlett stepped up very close to him and he pushed him back, and that's where the video picks up, where he was pushing him off and they started yelling and started the arrest process. So Bartlett claims that he was slow to respond to the command because of a back injury, not because he was drunk, right? And he claimed that Nieves said, "Bet you wish you would have talked to me now." So Bartlett was taken to a holding tent and charged with disorderly conduct. He was later released and the state ultimately dismissed the charges. And that's when, of course, Mr. Bartlett sues. Under 42 USC 1983, those who do these kinds of lawsuits call them 1983 actions, right? It's the portion of the U.S. code that you sue a state actor under when you feel that they have violated your constitutional rights. Protects the constitutional rights there. So Bartlett didn't sue for false arrest or imprisonment under the Fourth Amendment. He actually sued for retaliatory arrest under the free speech clause of the First Amendment. So he was basically saying, look, I was just exercising my right to tell other people that they didn't have to talk to you, and that's why you arrested me. He wasn't saying that they didn't have probable cause under the Fourth Amendment. He was saying that he was arrested for exercising his First Amendment rights. So the district court granted summary judgment and said, well, they had probable cause to arrest you anyway because you were drunk and disorderly. So you can't make a retaliatory arrest claim. And the Ninth Circuit, that great bastion of wisdom and common sense, disagreed, and they relied on their own prior precedent to hold that probable cause is not an absolute bar to a retaliatory arrest claim under the First Amendment. The Supreme Court granted cert, and the question for the court was, so does probable cause for an arrest defeat one of these claims? So let's look at a few of the past cases here. We talked about a few of these last year. Doyle was this civil lawsuit that a teacher had been working for this school district, and they didn't renew his contract. He didn't have tenure, but they tended to renew his contract every year for some time. And they said they didn't renew his contract because he had an unprofessional demeanor, and by that they meant he would get in fights with other teachers and staff, including my favorite, one over his not getting enough spaghetti at lunchtime. So he started making obscene gestures at students and yelling. He's flipping people off. He's swearing at everybody. It's a wonder this man was not, rehired to educate our children. And at one point, he called a local radio station to complain about the school board. And even though that was protected speech, the court said, look, because he brought a retaliatory firing claim and said, well, I was only fired because I went on the radio and complained about what the school board was doing. And they said, actually, they also had very good reason to fire you because you were getting in fights with staff and students and flipping them off and swearing at them. And that is not very conducive to a good educational environment. So under that, the court said, you have to show that the protective behavior, in this case, him going on the radio and complaining, was the but-for cause of his being fired. And under those facts, they're just, that might have been a little icing on the cake, but really, he was fired. He would have been fired had he not done that anyway, right? That was the upshot of Doyle. Hardman v. Moore. So Moore was a retaliatory prosecution claim. This was back in the 80s, and he created a machine that could read envelopes to help route the mail. And the Postmaster General thought, well, your technology reads the whole address, but we have this other competing technology that just reads the zip code, and that's actually a lot more efficient, because if we can get it down to the zip code, then the letter carriers can get it to where it needs to go, and their machine is much less expensive. But Moore was a very persistent kind of guy. He went and lobbied a bunch of congressmen and eventually got Congress to buy off on his tech and said, okay, the post office is now required to use this wonderful machine that I've created. But then the contract ended up going to somebody else, and postal inspectors ended up investigating Moore for his lobbying efforts, trying to see if there was anything that he could be charged with. And he was charged for a very brief period of time, but then it was dismissed for lack of evidence, and the case went away. So he said, well, you only prosecuted me for exercising my First Amendment rights to petition the government. I sincerely felt that my technology was the best way to help deliver the mail in a timely manner, and you were only trying to prosecute me because I was doing my best as a concerned citizen to convince Congress of that. And the court said, well, they had probable cause to charge you, for the grand jury to indict you, so that defeats your retaliatory arrest claim. So Lozman, we talked about this one last year, or a couple of years ago, I guess. That's Fane Lozman. He's the guy who lives down in Florida and is constantly suing the city and city councilors of Riviera Beach. He basically created a floating house, and he parked it in their marina for a while. And because of the way that he had constructed it, it wasn't quite a boat and it wasn't quite a house under maritime law, under admiralty law. It was a very complicated, kind of weird, funny case. And he has brought lawsuit against them twice and won. The first time was getting money back for them destroying his floating house. And the second time was for him standing up at a city council meeting complaining, and about 3 seconds into his presentation at the city council meeting, they just arrested him and dragged him out of the room because they were sick of hearing from him. And the court said, no, you can't do that. So he brought a retaliatory arrest claim, and the court said, well, just because you had probable cause to arrest him doesn't necessarily defeat his claim under those narrow circumstances, because he was actually in the process of exercising his right to address and petition the government at the time you arrested him. And what he alleged was kind of a special thing. He said, the city council of Riviera Beach actually has a policy to arrest me whenever they see me at one of these things. So with that specific allegation, the court said, well, the mere existence of probable cause, if you're telling your officers to be on the lookout for a particular person, and when they exercise their constitutional rights to arrest them, the court saw that as a problem. So that's all the background we have here on these other claims that are related to but not quite cover this situation. And I keep looking behind me, but I can look ahead of me here. So the court, via Chief Justice Roberts, he writes the majority, and he says, Lozman was unique because he alleged a very specific policy of the city council being prejudiced against him, essentially, and being out to get him. But in all other retaliatory arrest situations, the existence of probable cause is going to defeat it. This is from the opinion. For both claims, Chief Justice Roberts said, it is particularly difficult to determine whether the adverse government action was caused by the officer's malice or the plaintiff's potentially criminal conduct. In a lot of ways, for those who have been around for a little while, in Utah, we used to have what was called the pretext stop doctrine under the Fourth Amendment. So the courts wouldn't just look at, well, was there probable cause to or was there reasonable suspicion to pull this person over, or was there probable cause to arrest them, or was the officer acting out of some sort of improper motive? And that introduced an element of subjectivity into Fourth Amendment claims, which did not fly. We eventually got that taken care of, but that's kind of what was going on here. If you have if your name is Fane Lozman and the defendant is Riviera Beach, then you probably got a pretty good way to defeat this, even if there's probable cause to arrest you. Outside of that, you're just not going to get it. And here, as the chief said, there's a very tenuous causal connection. He was clearly being drunk and disorderly. And sometimes protected speech might be a reason to arrest somebody, but there's a time, place, and manner restriction. Just because you can get on your bullhorn and advocate for a particular political position doesn't mean that you can do it at 2 a.m. in a quiet neighborhood, right? And also the court talked about the need to defer to officers on the ground, making sure that they have some wiggle room to make these decisions that can look very different in hindsight than what they look like at the scene, right? Okay, so we'll talk about the common law in just a little bit. Section 1983 is generally viewed as enshrining common law torts as remedies for constitutional violations. So when you bring a suit under 1983, you have to show way back when this was something essentially that you could sue law enforcement for. So at common law, false imprisonment was the kind of claim that you would bring under these circumstances. And the presence of probable cause was a complete defense to that. And malicious prosecution under the common law required proof that the charge was unfounded or made without reasonable probable cause. So same kind of rule, right? No matter what you look at. But of course, there is going to be an exception. And that's supposed to be a GIF, and it's funny, but it's not working right now. So we'll just move on. This is the chief again. Although probable cause generally defeats one of these kinds of claims, a narrow qualification is warranted for circumstances where officers have probable cause but typically exercise their discretion not to do so. And if you look at the history of 1983, this actually makes sense because back when it was enacted, officers generally could arrest for misdemeanors only in limited circumstances. But now all 50 states allow arrests for most misdemeanors. So let's say that there's a big protest in downtown Salt Lake City and a number of the protesters jaywalk. They cross the streets not at the lights or whatever, even though there's no traffic. If you go and arrest those jaywalkers for protesting, they might be able to claim, hey, even though you had probable cause to arrest me, you almost never arrest people for jaywalking. So the fact that you did here shows that this is something that violated my constitutional rights. You were animated by a desire to motivate my constitutional rights. So there you go.
Okay. So, in the interest of recency and primacy, I wanted to make sure that I started off with a bang. And so I was looking through the cases that I was going to be presenting, and I was trying to decide on something that was going to be a real attention grabber, like ineffective assistance of counsel or due process, and I decided what better thing than restitution. So, in State B, and I'm not sure how to pronounce this person's name, Sabah, the question here is, what is the appropriate restitution when the wholesale price is actually higher than the retail price for which a particular item was listed for sale? And the answer is that we always lose on restitution, no matter what. So, in this case, the facts are as follows, and I'm just going to read them because these are the exact facts that were in the case, and I liked them. In June 2017, the bookstore at Weber State University was running a screaming deal on sets of wireless headphones. Although the store had paid a wholesale price of $299 for the headphones, it marked them for sale for just $175. But this deal, as good as it was not good enough for Bashar Sabah, who elected to walk into the store and steal 4 sets of the headphones. After being caught and prosecuted for retail theft, Sabah pled guilty, and the district court imposed a sentence that included a requirement that Sabah pay restitution to the store. So, at the restitution hearing, the various parties argued their positions. The state said that the appropriate restitution, as is always the appropriate restitution in a retail theft case, is the wholesale price. Sabah said that it should be the retail price because that more accurately represents the fair market value in a situation like this. And the district court, ultimately agreed with the state and imposed restitution based on the wholesale price, so the higher price. Now, on appeal, and the appeal was heard by Judge Ryan Harris. Wait a second, that's not Judge Ryan Harris. That's actually the late, great Jay Leslie, who was my supervisor over at the 4th District Court when I was a law clerk bailiff there. Unfortunately, Jay passed away in 2013 in a plane crash, but he was a good guy. But that's not him. There it is. Okay, there's Judge Harris. So, on appeal, the arguments are, or the court explained that a court will not disturb the district court's ruling on restitution unless it exceeds what is prescribed by law or somehow abuses discretion. Generally speaking, Pecuniary damages are going to be measured by the fair market value, which is essentially what somebody would be willing to pay if you offered it for sale. So he talks about the fact that the restitution, when you measure restitution, that it's flexible and that you're trying to fashion an equitable award considering all relevant factors and hopefully avoiding creating a windfall for the victim in the situation. This, though, is a unique situation because, as I said before, generally speaking, anybody who's ever done restitution on a retail theft case knows that wholesale is pretty much going to be what the restitution is. But here, where the wholesale is significantly higher than the retail, the court was like, I'm not so sure that we're not creating a problem by going with the wholesale in this situation. So, on appeal, Sabah argues that the retail price should be a ceiling and not a floor, which is a convenient argument for him to make since it benefits him and always hoses us. The state argued the concept of loss leader, and essentially what that is suggesting that a retailer will often put a particular item on sale at a very good price in order to coerce people to come into the store. They'll buy that item for the discounted price, but then hopefully they'll stay and buy a bunch of other stuff at a regular price. And this idea of drawing in shoppers this way then creates additional revenues. And essentially the state was arguing that based on this concept of loss leader, the store lost additional sales and should be compensated. And that's why the wholesale price in this case is reasonable and is what it should be. And the court said that while this may very well be a sound advertising strategy, the problem is trying to quantify it. Is that? I'm not sure why that's getting cut off on the bottom. The problem is trying to quantify it, and he said that the state has not presented any evidence to support some measurement of what these lost sales would be, and therefore the court is unwilling to go based on that. So, because compensatory damages are supposed to put the victim in the same position they were in prior to the crime having been committed, and in this case, where the retailer would have accepted the retail price, obviously, that it was offering it for sale for, then the wholesale cost and as restitution would result in a windfall. So the holding here is that ultimately the district court miscalculated what the restitution is, and it was remanded back down to the district court for further calculation based on the retail price rather than the wholesale price.
You know what my favorite loss leader is? Costco chicken. The price of a Costco chicken has been the same since like 1992. I read an article on this. And they say that customers are very sensitive to that price point. So they're never going to, it's not going to budge from like $5 or $4.95, whatever it is. And as we all know, it's impossible to go into Costco and not spend at least $100. So
Or to buy
it totally works, right?
Yeah, it does.
I was laughing too when you started your presentation on restitution cases. When I got my first restitution case years ago on appeal, my boss said, "Here's a restitution case, John. Do your best, but we always lose them." Sure enough, I lost it. So don't feel bad if it gets overturned on appeal. As Lance was saying, that's kind of the norm for a lot of our restitution cases, unfortunately. All right, on to Bucklew v. Precythe. Quick Eighth Amendment case on the death penalty and pain. So the question here, does the Eighth Amendment guarantee a painless execution? The answer is no. Imagine if it did. Well, then that would entirely prohibit executions because there's always going to be some sort of discomfort associated with someone taking your life, whether that's, you can imagine for whatever reason. So this case was essentially a challenge to the death penalty under the Eighth Amendment, and the court rejected it. So this is Russell Bucklew. On the left is when he committed his crime back in 1996. Looks like he just left a Radiohead concert or something. And today, there on the right, or at least a short time ago. When his girlfriend Stephanie said that she didn't want to see him anymore, he did the only logical thing that he could. He cut and punched her in the face and threatened to kill her. She took her kids and went to stay with a friend nearby. He actually ended up breaking into that house, shooting the friend in the chest, shooting at the friend's son, pistol whipping Stephanie, handcuffing her, kidnapping her, raping her, and killing her. So he's a gem, right? He was arrested, but he then escaped from jail and attacked Stephanie's mother with a hammer before he was recaptured. So a very, very dangerous person. Quite a guy. He was convicted of murder and sentenced to death in Missouri. He went through all the usual process: direct appeal, state post-conviction and appeal, federal habeas and appeal. He lost every single one of them. So like a lot of other death row inmates around the country at the time, he was set to die by lethal injection. And like many of them, he started to raise a challenge to what was then the 3-drug protocol. There were 3 different drugs that the state injected you with in succession to bring about your death. This resulted in a lot of wrangling with drug companies, shortages of drugs around the country, because a lot of people opposed to the death penalty would go to the drug companies and lobby them to stop producing the drugs. And that was fairly effective, so there began to be a shortage of the drugs to bring this about. And anyway, inmates on death row kept bringing all these challenges to, well, this 3-drug protocol is too painful, it might cause me discomfort, all that sort of thing. And after the dust settled on which drugs could be used, the Supreme Court decided a case called Bays v. Reese back in 2008 that said, look, if you're going to prove an 8th Amendment violation, the petitioner has to identify another protocol that would substantially reduce the risk of severe pain. In Utah, that meant we just reinstituted the firing squad, which incidentally, even Justice Sotomayor, who is no friend of the death penalty, agrees is essentially painless and poses little risk of mistakes. But anyway, this is kind of the background of what's going on, all this wrangling over these drug protocols. So Bucklew brings his claim, and he said, even though most people would not suffer under this new drug protocol that Missouri has, I would, because I have this unique condition called Cavernous Hemangioma. So basically, he gets blood clumps all over his head, neck, and throat. You can see one there on his upper lip. He gets these odd blood clots around his body. Essentially, he claimed that if they used a sedative on him, it wouldn't circulate properly through his blood system because these blood clots might impede the progress of this sedative. And if the sedative isn't working, then the clumps are going to rupture and inflict a lot of pain, and he's going to feel the pain from the other drugs that bring about his death, and it might actually cause him to suffocate. So to comply with Rees, he said, okay, I have to propose a less painful alternative. How about using nitrogen gas on me? Nobody had ever done that before, so he was thinking, why not for the first time? The district court and the circuit court ruled that he had not shown that nitrogen gas lowered the risks that the injection protocol already posed. So they rejected his claim. Here's the 8th Amendment with the money language highlighted. No cruel and unusual punishments, right? So is the risk of pain either cruel or unusual? That requires us to look back to history. And enter Justice Gorsuch. So the court, on a vote of 5-4 with Gorsuch writing, didn't think so. It was a very strongly originalist opinion. If you have any questions of what originalism looks like in the wild, then go read this opinion. It's a very good example of it. I have the money language highlighted. He basically says, look, the Constitution permits the death penalty so long as due process is complied with. And death was the standard penalty for serious crimes at the time of the founding. So every now and then somebody tries to claim that the death penalty violates the Constitution because it in itself is cruel and unusual. But the Constitution itself permits the death penalty for things like treason. So the court, again, narrowly, but given the current composition of the court, just said, we're not going to go there. You're not going to convince us that the Constitution does not permit the death penalty when the Constitution itself permits the death penalty. But at common law, he said, what they were talking about were things that were intentionally cruel. So things that, when you're using torture or disgraceful methods like drawing and quartering, disemboweling, all the kind of stuff you might see if you watch Braveheart, right? These things had fallen out of use, and by the time of the founding, those were unusual because they were not the usual means of bringing about an execution. So if something is unintentionally cruel, that is, it's not meant to inflict pain, but it's not entirely painless, those things weren't unusual at all. Things like hanging were common, and somebody could live for a time while they were being hanged. If their neck didn't snap immediately, they might suffocate, that sort of thing. The court said, whatever the morals of causing somebody pain when taking their life, that was not forbidden by the Eighth Amendment as originally understood. So the Eighth Amendment, what it does stand for, as the court says here, doesn't guarantee a painless death, but not merely one by outdated methods that were meant to inflict pain. And incidentally, the court says, we're kind of out of the business of intentionally inflicting pain. In fact, states have gone out of their way to find methods that inflict as little pain as possible, maybe just the pain of being pricked in your arm by the needle, essentially, right? So we're not headed in a direction. This isn't the kind of opinion that's going to open up the floodgates to grisly executions, right? That's not how we do things anymore.
Okay. Thank you. By the way, is striven, is that a word?
Oh, yeah.
Okay.
It's the past participle of strive.
I mean, I figured, but still, I've never used that word in that
You
context.
can say
but-
strive. They're both acceptable.
Okay, like pled and pleaded. Although it's pled, by the way, it's not pleaded. Anyway, so this next case, State v. Carrick, has come to be affectionately known as the Man from Snowy River case, hence this fun clip that we're all going to enjoy for a minute. I don't know why the dialogue there is in a different language. Stop asking questions. So, a couple of comments about that scene.
filmed in Italy, right?
That's right. First of all, if your stirrup comes off your saddle that easily, I feel like your saddle's broken. Secondly, those of you Man from Snowy River purists out there, I understand that this was actually Return from Snowy River, which was a garbage movie, except for this scene right here. And I couldn't think of a particular scene in the original, the Man from Snowy River, that I thought was kind of quite as cool as this scene. I mean, running down the mountain, like, that's pretty cool, but this one was awesome. So I apologize. Return to Snowy River, not the Man from Snowy River, but you get the point. Okay, so this case, here are the questions. Number one, can a burglary survive a directed verdict challenge when there is no evidence that anything was taken? The answer to that question is a definite yes. And number two, is a statement from a third-party witness to another witness about the motive of the defendant in going into the house in the burglary admissible under rules of hearsay, under rules of confrontation. And here it is, but because it's not hearsay, because in this particular situation, she was asked about the statement before it was admitted, and she denied having made it, which made it a prior inconsistent statement, which makes it non-hearsay. So, sorry, running two screens at the same time. So, Mr. Carrick was having an affair with wife. Husband found out about the affair, and shortly thereafter, wife passed away. Now, the court makes no comment on this glaring question that I'm sure is in your mind and that was in my mind, but as far as I can tell from the opinion of the court, there was no connection between the husband finding out about the affair and the wife's passing shortly thereafter. So wife passed away, everybody's sad. At the funeral, Mr. Carrick showed up. And he was wearing a cowboy hat. And I don't know exactly what the hat looked like, but what some of the witnesses described it as was a hat that had some sort of unique feather situation going on. Could have been any of these, could have been something different, but one of the witnesses described it as a Man from Snowy River hat. And the defendant, during his testimony, said, yeah, that's probably pretty accurate. Plus a feather. On the day of the funeral, right after the funeral, a couple of the neighbors to husband and wife who had been in attendance at the funeral came home right after and saw a man with a distinctive hat that had a feather on it that looked like the man they had seen at the funeral with that same distinctive hat, crawling in through a garage window in the home of husband and wife. And then a short time later, they saw him crawling back out that same window. He didn't seem to have anything that he was carrying or anything with him. He jumped into an SUV that was waiting for him and drove away. Officers contacted those witnesses, talked to them, brought up Mr. Carrick's social media posts or social media profiles, showed them to them. They positively identified him as the person they had seen. They also pulled up his driver's license record and used that photo, and the witnesses positively identified him from that as well. A little bit more suggestive than probably we would like to see, but that's what happened, and the court didn't take any issue with that. And then one of the witnesses, a witness who turned out to be an alibi witness for Mr. Carrick, who was also a friend of husband and wife, actually, when police interviewed her, she pulled out her phone, called Mr. Carrick, and then handed the phone to the officer. And the officer said, "Hey, I need to talk to you. Can you please come and meet with me?" And he said, "No, I'm busy. I'm on my way to Salt Lake," hung up, and they were never able to get in touch with him again during the investigation. When husband got home, the only thing that he noted was that his golf clubs appeared to have been moved. But other than that, he couldn't see that anything was missing or that anything had actually been taken from the home. So, Mr. Carrick was charged with burglary. In the jury instructions, all the appropriate mental states were there, but the only one that was actually defined in the jury instructions was knowingly. So intentionally and with intent were not defined in the instructions. After the state presented its case, Mr. Carrick moved for a directed verdict, and the court denied that. During the defense's case in chief, Mr. Carrick presented 4 alibi witnesses, all of whom basically said that the various hours right after the funeral, which was during the kind of late morning, so everything from the early afternoon into late in the evening, those 4 witnesses were pretty much able to account for Mr. Carrick's whereabouts, and all said that he couldn't possibly have gone to the house and been the one who went there and committed the burglary. One of the witnesses, the one that I was talking about that pulled out her phone and called Mr. Carrick, and I hope you guys are seeing the bottom of this. It's not showing on our screen here, I'm not sure. But anyway, she said she denied having told husband that a few days after the burglary, when he asked her why Mr. Carrick had gone into his house, that she said he just went in to get some kind of memento or something to remember wife by. She denied having made that statement. And further, she said, "I told husband when I did talk to him that I actually thought it was wife's cousin who had committed the burglary because he's known to do that kind of thing, specifically during funerals." So, on rebuttal, after her cross-examination, where she denied having made that statement to husband, they called husband to talk about it, to talk about having spoken to her a few days later and her having said that Mr. Carrick went in to get a memento or something to remember her by. The defense objected based on hearsay, and the court overruled the objection, saying that it wasn't being offered for the truth, but it was being offered to impeach the witness. Ultimately, Mr. Carrick was convicted of burglary. So, on appeal, and Judge Gregory Orm was the one who handled this for the Court of Appeals. Wait a second. That's not Judge Orm. That's Michael Jeter, which you may know from such films as Waterworld, Open Range, and The Green Mile. There's Judge Orm. Okay, so he did the appeal here. And Mr. Carrick on appeal argues ineffective assistance of counsel and requested a 23B hearing to send it back and to be able to present evidence of all of his counsel's various failings, which included quite a list of things. He said that he should have gotten an expert to talk about eyewitness testimony. He should have investigated some of the CSI practices used by law enforcement. He should have gotten additional alibi witnesses. He should have investigated cousin better. He should have investigated an officer's relationship with the neighbor, as well as the fact that he knew the code to their garage. Therefore, he would not have gone in through the window. The court allowed 23B on 3 issues: the alibi witnesses, the cousin, and the garage code. So at the 23B hearing, the court made the following findings. That Mr. Carrick failed to make his counsel aware of any other alibi witnesses besides the 4 that they had in fact called at trial. That Mr. Carrick had told his counsel about the garage code, and that the defense investigator had looked into Cousin, and aside from his relationship with wife, that there was nothing to indicate that he was involved or to put him at the scene or connect him in any way to this crime, so they had not pursued that further. On appeal, Mr. Carrick makes 4 primary arguments, one of which has 4 sub-arguments, so buckle up. Number 1, that his directed verdict motion was denied erroneously, that hearsay was improperly admitted, that the jury instructions were improper where the other mental states were not defined, and ineffective assistance of counsel with 4 subsections, those being his failure to object to the jury instructions, his failure to present evidence of the garage code, his failure to investigate and present additional alibi witnesses, and his failure to more thoroughly investigate Cousin. So, the issue of directed verdict. Carrick basically says that the state failed to show that he had an intent to commit theft, even if he had entered the property, which he also denied. The court says intent can be proven by circumstantial evidence. See, proven, not proved. And that some of that may include the manner of entry, the time of entry, the contents of the building or house, the actions of the defendant surrounding the time frame, the totality of the circumstances, and any explanation that the defendant might have given. The court in this case feels that there was ample evidence to support the conviction, including the fact that he had been having an affair with wife, the fact that he was emotionally upset over her death, his manner of entry and exit, his desire to get a memento, and the timing relative to the funeral. The court said that there is at least some evidence, even if it's not ample, which is all that the law requires. Now, as to the hearsay statements, and this I kind of addressed it in the opening there. So the witness denied having made the statement when she was cross-examined, making it a prior inconsistent statement. And a prior inconsistent statement is not just an exception to hearsay; it is non-hearsay. Carrick's argument was that it shouldn't have been able to be used substantively. The court addresses that in a couple of different ways. Number 1, it says, well, and the substantively that he means is the way it was argued in closing statements or closing arguments. The court says, well, if you didn't like how it was used in closing arguments, then part of your appeal should have been that your counsel was ineffective for not objecting during closing arguments, and you didn't make that argument. So you don't get to challenge that in this way now. But also, the fact that it's non-hearsay as opposed to an exception to hearsay, or as opposed to something that would be hearsay but that's not being offered for its truth, means there's no limitation on your ability to use it substantively. You don't have to argue something that doesn't go to the truth of the statement because it's just not hearsay, so you can argue anything you want. So no issue there with the alleged hearsay statement. On the jury instructions, this was not preserved, so he has to argue plain error. And specifically where the trial court asked counsel if he had any issue with the jury instructions, and he said he did not. Oops, got a little ahead of myself here. The court found this to be invited error, the purpose of which is to essentially discourage parties from intentionally creating errors in the system to be able to then raise them on appeal. And because of the stipulation, he cannot proceed under plain error. Invited error and plain error can't exist in the same plane. So he's going to have to attack this through ineffective assistance of counsel, which, of course, he did. Now, ineffective assistance, and you'll recall that there were 4 things that he was arguing here. He has to show deficient performance, which is going to be that the performance fell below an objective standard of reasonableness. He also has to show prejudice, which means that but for the errors, the results would have been different. We're going to talk about this standard a lot today because I have like 17 ineffective assistance of counsel cases. So
You're welcome.
Yeah, thanks, John. On the jury instructions, ineffective assistance of counsel. Nobody objected as far as the lack of a definition of intent. which the court finds perplexing, as do most of us. But it happens, and we all forget things, and trial can be a very busy time. So ultimately, what the court decided with respect to intent and the lack of a definition there is that the definition of intent, the legal definition or intentionally, is so close to just the common community understanding of those terms that the court's not concerned that the jury would have done anything but apply the appropriate definition. They also found it significant that the state's arguments didn't go outside of that sort of common understanding of what intent or intentionally means too. So even though it wasn't specifically defined, basically the fact that that everybody's understanding of what intent or intentionally means jives with the legal definition of those terms, that it was harmless. The garage passcode. So again, the defendant says that he would not have gone in through the window because he knew the code to the garage and he could have just opened the garage door using the code. And counsel did not present evidence of that. The court says a couple of things. First of all, there were 4 witnesses who identified Mr. Carrick as being the person who went into the garage. Also, there could be reasons, even if he had known the code, why he may have gone in and out of the window in any event. Number 1, drawing attention to himself by opening the large garage door in the front of the house. Number 2, so that he could actually come in and make this very argument, saying, I know the code, and if I know the code, why would I go in and out of the window? And number 3, which the court didn't say, but my thinking was the system may very well catalog every time the garage door opens and closes, and so if somebody goes back and looks at the system history and sees that it opens and closes using the code, that they would be able to narrow the list of suspects to people who knew the code. In any event, the court says it wouldn't have made any difference because of these alternative inferences the jury could have drawn from this argument, and it wouldn't have done him the good that he thought it would have done. Additional alibi witnesses. So the trial court found that he had not disclosed that there might be potential other alibi witnesses to his counsel. The court says counsel is required to investigate, but they're not required to investigate the entire world. And where they had 4 solid alibi witnesses that they already presented to say that not going and looking for more was ineffective assistance, the court's just not going to go there. So he says counsel's performance was not deficient. And then finally, as far as ineffective assistance, the investigation of Cousin. And this is interesting to me because they did investigate Cousin, and the defense investigator basically came to the conclusion that based on the physical features of Cousin as compared to Mr. Carrick, Cousin's unknown whereabouts at the time this happened, and the fact that there is nothing else to tie Cousin to the scene of the crime other than the fact that he's wife's cousin and has a propensity to do this, that they didn't investigate further. So the court assumes without deciding that failure to investigate further was in fact deficient in this case, which I was very surprised by because I don't know why he needed to make that assumption. They did investigate, and they did investigate pretty thoroughly. So for him to say that he has to assume that the failure to investigate further was deficient is odd, and I don't know why they did that. It's also interesting, and you'll see this in some other ineffective assistance cases, where the court feels the need to tackle the 2 prongs of ineffective assistance, so the deficiency prong and then the prejudice prong, in that order. Therefore, having to say, well, we're going to assume deficient performance here, but then we'll jump to the prejudice prong and find there was no prejudice. In some of our Supreme Court of Utah cases, you'll see that they didn't bother with that. They just skipped right over the deficiency, went right to the prejudice, and decided the case on that basis that there was no prejudice, not ever having addressed the deficiency issue, because where both have to be met, it makes some sense to take them in that order and probably to analyze them in that order. But as far as the court having to say, well, we're going to assume deficiency so we can get to prejudice, I don't think they have to do that. In any event, he said there was no reasonable probability of a different outcome because the investigation of Cousin just wasn't going anywhere. So the holdings in this case, no error in either the directed verdict, the hearsay objection, or the jury instructions. No ineffective assistance of counsel as to the jury instructions, the passcode, Cousin, or the additional witnesses. And ultimately, Judge Orm affirmed the district court on this.
You know, I've always thought Judge Orm looked more like Teddy Roosevelt.
Oh man,
too.
Yeah. Just a couple of things on Carrick. You're right about him assuming, it being a little strange that he assumed deficient performance just to get to prejudice and reject the claim. I actually had a discussion with him at an oral argument last year where he seemed pretty intent on assuming something I thought he didn't have to assume. So he's aware of this issue, but he just thinks differently about
Does
it.
he know what happens when we assume? Did you explain that?
We didn't get to that issue. We had other things to talk about. But Carrick is a good one. We're seeing more and more 23B motions these days, and when we get them, our office tends to come help. The presumption is that the trial attorney or attorneys are going to do that hearing with help from the appellate attorney. I've done it several ways. If it's a very experienced prosecutor, I've just kind of kicked back and watched them do it, and then they consult me at the end of their questioning and see if there's anything they missed. Our office tends to do a lot of the filings, so the motion practice and all of that. But this case is a really good illustration of something that keeps coming up over and over again, because whenever they say, my attorney messed up, he should have done this, should have done that, whatever. The reason why these hearings can be helpful is Strickland itself, Strickland v. Washington, says that counsel's decisions depend critically on what the client tells them. And sometimes defense counsel will try to do a 23B hearing without calling the attorney, and I don't know how they can possibly make their case without that, but they try. So if they don't call the attorney, then by gum, you call the attorney and you talk to them and you get them to say, what did your client tell you? Because 9 times out of 10, that's actually going to defeat the claim. Because like, well, they never told me about that. Had they told me that, I would have looked into it. So something to be on the lookout for if you get one of those 23B motions. And of course, if you do see one in your case, be sure to talk to the appellate attorney so we can help walk you through it.
So it's 10 o'clock. Bob, should we take a break now, or since we started a little late,
That was
should
a
we
good
go 5 to 10?
time. Yeah, so
All right.
tell them we're
We'll
going
take
to
a break.
take a 15-minute break.
Okay, we're going to take a 15-minute break. We will be back at 10:15. See you then.